If I trademark SpoodyDoo, does it also cover SpoodyDoo Consulting? And if I trademark consulted SpoodyDoo, is it also protected? I'm talking about a US-based scenario.
Yeah, good question. I get this one a lot, right? So if you register SpoodyDoo and you're in like class 35 for like business consulting services, yeah, you're protected for anything kind of related to that in the business consulting field, right? So business services, probably hiring, recruiting, consulting services. And you don't necessarily need to add words like consulting or consulted or yeah, because at the end of the day, those words are descriptive of the services you're providing. And what you're really registering is the word SpoodyDoo. So, like, for example, if you were to try to register SpoodyDoo Consulting at the USPTO, let's assume that the USPTO said yes.
Right.
They're going to cross off the word consulting because it's descriptive of the services you're providing. And you can't have the exclusive right to use the word consulting in the consulting field. So that word gets scratched off. So you can't force that word. So what I always tell clients is like, do you want to be on your website or with your clients? Do you want to be known as like SpoodyDoo, or do you want to be SpoodyDoo Consulting? Right? Because you can be either one. Just pick one and be consistent with it.
Consistency. Okay. Got it.
For a lot of clients, like who are using like a coined term like SpoodyDoo, which I have no idea what the hell that is. So it makes sense to put the word consulting behind it so that your clients have an idea of what it is that you do. Right?
Yeah. Love it. Yeah.
So.
No, it's awesome. Awesome answer.